Microphone test, 1, 2, 3.
right, so it's, on my clock, it's 9:31, so we're going to call the Court of Revision to order. Today we have Court of Revision followed by Committee of Revision due to some legislative changes in 2006, 2008. Everything before, all local improvements before 2006 are considered by the Court of Revision. Of course, everything after 2008 is considered by the Committee of Revision, thus the two different committee/court. So we're going to get right in. The only thing on the agenda, I guess we do declarations of interest. Seeing none. Confirmation of minutes from the meeting of June 24th, 2013.
Mr. Chair,
Yes.
I have an amendment to the minutes.
Yes.
I'll read them out. Councilor Harder has previously advised that an amendment should be made to the minutes of Item 2, Local Improvement, Paget Road, Sanitary Sewer Extension. The minutes reflect the following recommendation: that the Court of Revision receive and approve the Local Improvement Special Assessment Roll for Paget Road Sanitary Sewer Extension. Attached to the memo dated June 21st, 2013, from the General Manager, Infrastructure Services as Amendment 1. However, upon review, it was determined that the memo mentioned above incorrectly referenced an amendment to the local improvement for Paget Road, when in fact there was no amendment. Therefore, the recommendation at Item 2 of the minute of 24 June 2013 should be amended to read as follows: that the Court of Revision receive and approve the local improvement special assessment roll for the Paget Road Sanitary Sewer Extension project as outlined in the project. Is that okay?
That's carried? Carried. So, confirmation of minutes then is carried as amended?
As amended.
Excellent. So one item on the agenda today is the local improvement for the Navan Road water main extension. So obviously this was deferred from our meeting in June. So if I can just ask staff for an update on, we had asked, after the delegations at that time, we had asked staff to go back and look at a couple things and report back to us. If I could just get an update on what has come of that since June.
Mr. Chair, there was a submission from certain residents in Navan dated June, and it was staff's understanding that the Court of Revision wanted staff to look at it and provide a response to the Court of Revision. That was done yesterday, and I can quickly summarize the points that were raised and the response. With respect to the Limitations Act, it's staff's opinion that we've consistently given that the charges are not crystallized until they're approved by this body, and therefore the Limitations Act does not apply. There was a concern with respect to whether or not the pipe had been oversized and were the residents being asked to pay for a pipe larger than they needed, and Infrastructure Services staff confirmed that such wasn't the case. There were concerns or comments made at the meeting with respect to the cause of the need for the water main being possibly concerns over contamination that may have resulted from development in the area. There are two responses to that, Mr. Chair. The first is that that type of matter goes to whether or not one moves forward with a local improvement in the first place or not. And if that matter was to be raised, it would have been appropriately raised back in 2003 when the local improvement petition was before committee and council for approval. The petition having been approved back in 2003, that is, in the opinion of staff, determinative of the matter. But staff can go on to say that even where there has been cases of contamination in the city and its predecessor municipalities, residents have been required to contribute to the cost of installing water mains. And so the history is that in the extension of water supply, residents are required to contribute to the cost of the water supply. In the end, it is not, in my respectful submission, a matter for this body to address. Subject to any questions the Court of Revision may have, that's the staff response to the matters raised in the letter.
All right. Can you also just reference the motion by council that was passed recently regarding those who may have purchased homes in subject areas after the work had been done, and before, obviously, we got to this point at the Court of Revision.
So a motion was passed by council in April of 2013 that provided that where someone purchased a property after the local improvement was constructed, that person swears an affidavit of statutory declaration saying they were unaware of the local improvement when they acquired the house, and where they had acquired a tax certificate that did not show the local improvement on it, then council will waive the collection of the fee. To be clear, the Court of Revision would still impose it. It's just that the motion adopted by council is a direction to staff that they do not collect the fee.
So it gives the resident or the homeowner another alternative after this meeting,
That's correct.
should they be able to meet those conditions.
Yes, and some, in other cases in the Court of Revision, some had actually supplied the information to us before the Court of Revision met, but they can still supply it afterwards, yes, Mr. Chair.
All right. Mr. Gontier, Mr. Martin, do you have anything to add before I go? Do we have at least one delegation? We have 2 delegations on this. Did you have anything to add before we go to that?
No, Mr. Chair.
Councillor Kaji, any questions? All right. So we're going to go to our delegations. I know the first delegation that we have is Mr. Barry Hayden. So if you just come up and take your seat. Pardon me? Yeah, so you're going to come up together? Okay. What's the 10 minutes? Yeah. You essentially have each have 10 minutes, so you can do with it what you will.
There. That time? Okay, we're good. Okay. My name is Ava Hardy, and I was at the previous meeting. We would like to actually start by expressing appreciation to this board to allow us more time to gather some of the documents that are relevant to this matter and to sort of figure out which end is up in some ways. Also, I'd like to express appreciation to Tim Mark and his staff for providing us with documents and various forms of assistance and information. It's all been very helpful to us. However, we'd like to just sort of comment on some of those things and report back on sort of where we're at and what we'd like to ask you at this point in time. We did look at the case that Mr. Mark has been citing in terms of the statute of limitations, and in sort of preparing for this, we looked over that, and we discovered that the statute of limitations is actually not even mentioned in the court case, or in the case that he's talking about. The whole thing is based on a Local Improvement Act of 1990, and that's the only act cited in that case, and the statute of limitations is not mentioned. So to us, there's still a very large question about the application of the statute of limitations, and I know this is not the place to be addressing or arguing that, and all I'm doing is stating that for the record. Okay. The other thing that we look at is the matter of title insurance. I think Mr. Mark would be able to agree with me on this, that there is a provision for those of us who did not get a tax certificate and who had acquired title insurance, with the understanding that one way or another, those of us who purchased after this work was done with absolutely no knowledge of the work having been done or any amount outstanding. There was, to my understanding, the spirit and the intent of what was set forward was that those of us in that position would not necessarily be caught in that position and left with the bill, but unfortunately that's exactly what's been happening, because it's not standard procedure anymore for lawyers doing conveyances to obtain a tax certificate. They get a clearance certificate and they get title insurance, and that is standard procedure. And that might not have been something that the board was aware of at the time that that particular relief program was set up. And when I look at the preponderance of correspondence and the meeting minutes, in the letter of June 20th from Kent Kirkpatrick, it was stated that this relief was available. The Finance and Economic Developments Committee report of April 2013 also talked about this dispensation policy and the ability to extend relief to those of us in that position. The letter of May 24th from the city advising us of these outstanding amounts and this Court of Revision, and also an email from Tim Mark as well, talking about the relief. My understanding is the spirit and the intent is to assist us. And unfortunately, because of the provisions in that relief program, it has not been of assistance to us. And because it's not an actual tax, our title insurance companies have been turning us down. So we are left with the amounts outstanding, and we know that that's not the intent of the city. And Tim Mark sent me an email 2 days ago on the 24th saying that they're examining the title insurance question versus the tax certificate matter and matters of due diligence. Basically, we have, for the most part, done due diligence, not just people in Navan Road Water Improvement Project, but I'm sure others as well, getting the usual standard forms, the usual due diligence that the conveyancing lawyers do, the title insurance, all this sort of thing. The due diligence is done, and we would ask that this be looked at again and other forms of due diligence accepted for the relief program. So what we're going to ask is that time be given for that to be looked at again before this matter is actually set down and confirmed, and possibly also that other people's situations be looked at. I think you're aware that there's one individual in our project who tried on several occasions for over a 9-month period after the work was completed to make payment because they'd remortgaged their house so that they could. The money was available. Unfortunately, she was always told that no one knew who was working on that file and to wait. And the monies were used up. They had a business of their own at that time, and I'm sure a lot of it went to that. Her husband has since had not one work accident, one car accident. His earnings power is diminished. They have 2 teenage sons. Everybody knows that that can be expensive. There's other people also who have retired or had other unfortunate circumstances. If there's some ability to make some provision for those people as well, I would ask that that be looked at. But in the meantime, we would like this to be set aside for another period until it can be just dealt with in terms of the matter of relief for those who have purchased after the work was done, as well as people who have had altered circumstances in the intervening time.
My mic button doesn't work very well. All right, so it's fine. I'll just hold on to it. Did you have any? Did you want to speak to Barry? Yeah, just throw your mic on.
One of the properties, one of the larger properties now owned by a church, as far as I know, is very large. They have a bill for $45,000. I'm just wondering why that property, which was a site at the time, and as I say, is very long, why the pipeline was extended way to the very end of that property, the extreme east. And the other thing I'd like to know is the deal that's already been done with one of the houses up the street from us. I'm sure Tim Mark knows of it. A figure's already been worked out with them.